trademark is that it's a badge of origin. It's a source indicator. And when you see a trademark, particularly the ones above you, that are on the screen ahead of you there, is that you're seeing a brand or a company that are saying that these are my goods. And everything that has come, all the marketing and all the effort that's gone into them putting that brand together is encapsulated in that trademark. And it's obviously been decided along the line that these marks deserve the protection of the law. The law relating to trademarks is your trademark can be protected in two ways. The one's through the Trademarks Act, and that is for your registered trademark. The other way, you're not completely without protection. There's a common law action called passing off, which protects your trademarks or your marks that you're using as marks. So you can get protection if you build up a reputation in that brand and other people knock it off. So it's more difficult to prove. It's not as easy to enforce your rights. Obviously, the trademark registry is there to provide certainty to all the proprietors that own their trademarks and have them registered. So you are better off having a registered trademark, but there is a level of protection for you. The right to copy, it's an exclusive right for the owner that created the works, and the works defined by the Copyright Act include things like artistic works, literary works, musical works, as well as dramatic works. And that you need to know about copyright. So all your drawings and all your prints and stuff, they do have copyright in them, and they actually do have copyright in it today. You don't have to register them. There are no formalities to get copyright protection. All they have to do is meet the requirements for copyright. So they have to be considered as a work, and they need to be original as well as fixed in a material form. Fixed in a material form, the way you just need to understand that is there's a maxim that says that there's no copyright in ideas. So you need to actually have it written down. So you can tell your friends about the design that you really want to, the dress you want to put together. But until you've got the drawings and you've got the dress put together, you don't have any protection in that from the law. The third area that I'm going to talk you through very briefly is know-how and trade secrets. So your trade secrets are the confidential information that gives you an advantage in the market, and generally it's protected if it's obtained in confidence. So you can't use it then to the detriment of the person that disclosed the information to you. It's a very underdeveloped area of law. There's no legislation in South Africa, although there is in other areas of the world. And so the way that you protect your trade secrets is contractually. So that would be through non-disclosure agreements or confidentiality clauses, and also through your employment agreements. So you could have restraints of trade that stop you doing it.
A little bit about patents. Patents are the appropriate form of IP protection for an invention. So when I'm talking about an invention, I'm talking about anything that is a process or a product or any kind of technological improvement, for example. So a patent grants you a right of monopoly over your invention. So what that means is you will have exclusive rights to exploit your invention commercially and hopefully make a lot of money out of it. But if we think that a patent covers a concept maybe of how something works, a registered design would protect more the look and feel of something. So if Nike patented their cushioning technology, they would file a registered design for each model of the Nike Air running shoe that comes out.
We had a talk with Adams & Adams, their law firm. They taught us about copywriting, trademarking your brand, and how even like a print, something as small as a print can be trademarked as well. But what I took from the entire talk is that you can sell your brand, like your name, but you can't sell. You can also not choose not to sell your reputation. I found it weird in a bit, but I understood what it meant after they explained what it actually meant, and it did make sense in the end. That's like the one thing I took from it.
Yeah, Adams is a law firm, but it's great that they also have something to cater for us as artists, you know, speaking
Yeah.
about intellectual property and what you need to know while you're starting up, and, you know, so it was very informative. There's a lot of stuff that we learned about prints and logos.
Because most of us
and-
don't know
Yeah, and
what that is.
yeah, so that is very helpful for us.